Number 4.
How do you plead to that? True or not true?
True.
And on or about the 12th day of June 2025 in Bexar County, Texas, the defendant Ruben Rendon Jr. did then and there fail to comply with the rules and regulations of felony drug court.
Tonight's docket jumps straight into real stakes. State versus Ruben Rendon Jr., a robbery case on community supervision that's suddenly hanging by a thread. Missed check-ins, skipped drug court, and a brand new fail to ID offense are about to collide with a judge who does not play when it comes to accountability. Watch how a single word, true, can flip the switch from help to handcuffs, and why the state wants prison while the defense begs for treatment. And don't blink, because right after this revocation drama, we pivot to Mr. Martinez and a high-tension PR bond fight that turns on missed drug tests, money, and flight risk claims. Who earns another chance, and who gets locked in? Let's roll.
All right, court is calling 2024 CR 011707 State versus Ruben Rendon Jr. Can I have parties announce?
I want the alpha.
Sean Sheffield for defendant. We're ready now.
And are you Ruben Rendon?
Yes, Judge.
All right, did you review the documents entitled Motion to Revoke Community Supervision, First Amendment Motion to Revoke Community Supervision, and Second Amendment Amended Motion to Revoke Community Supervision? Did you receive that and review that with your attorney and understand it?
Yes, Your Honor.
Are you the same Ruben Rendon Jr. who's placed on community supervision in 2024 CR 011707 for the offense of robbery on February 3rd, 2025 for a term of 8 years? Is that you?
Yes, sir.
All right, state.
We're going to proceed on the first two on the original, Your Honor. The only one on the second amendment. In Bexar County, Texas, the defendant, Ruben Rendon Jr., did then and there fail to report to the supervision officer as directed for the months of June and July 2025 in violation of condition number 4.
How do you plead to that? True or not true?
True, Your Honor.
And on or about the 12th day of June 2025 in Bexar County, Texas, the defendant, Ruben Rendon Jr., did then and there fail to comply with the rules and regulations of felony drug court, in that the defendant failed to appear in court in violation of condition number 41.
How do you plead to that?
Your Honor.
And lastly, in violation of condition number 1 on the second amended, on or about the 31st day of August 2025 in Bexar County, Texas, the defendant, Ruben Rendon Jr., committed the offense of failed to ID in violation of condition number 1.
Let's unpack those violations the state just read. Condition number 4 is basic probation hygiene. Report to your supervision officer. June and July, no shows. Condition number 41 is felony drug court compliance. Fail to appear, and you're signaling the program can't help you because you won't show up to be helped. Then there's the August 31 fail to ID. In plain English, not properly identifying yourself to law enforcement. When the defendant pleads true, he's admitting these violations happened, removing any factual dispute. Question for you. At what point do missed check-ins stop being struggles and start being choices? And how much should that last new offense weigh compared with earlier progress? Drop your take below.
How do you plead to that? True or not true?
We'll waive the rest.
Any objection to the waivers?
No, Your Honor.
Did you understand by pleading true to violations 4, 41, and 1, the court could find it true, grant the motion, and sentence you up to 8 years up to 10 years in the prison? Knowing that, do you still wish to plead true to violation of conditions 4, 41, and 1? Court will find 4, 41, and 1 true.
Catch the judge's warning. By pleading true, the court can grant the motion to revoke and sentence up to the statutory cap tied to the original offense. Here, the judge says up to 10 years. That's the revocation reality. Community supervision is conditional freedom. If you violate, the court can pivot from treatment and structure to TDCJ time. Notice the state isn't even asking for the max. They're recommending 6 years. Strategy-wise, the defense must now sell rehab over retribution, citing treatment history, relapse risk, and public safety upside if recovery succeeds. Would you take the state's 6, or roll the dice on the judge after that warning? Tell us why.
Their proposed agreement.
There is not, Your Honor. The state is recommending revocation and 6 years TDC.
All right, defense, what are you requesting?
We're requesting actually the recommendation from the probation office is that he gets additional help for drug issues that he has. We're asking the court to follow that recommendation. We're asking for safety. He understands that he would have to leave. He's willing to do so. He also is telling the court that he has a problem. He did complete the lifetime inpatient. However, once he was released, he had some issues after that.
Smart defense move. Anchored to probation's recommendation for additional drug treatment. Probation officers live with the case day to day. Their assessments can carry serious weight because they see who engages and who absconds. The state counters with the violation pattern, framing non-appearance as proof treatment chances were wasted. Judges often weigh 1. Public safety, 2. Amenability to treatment, and 3. Credibility. Does the defendant own the relapse and show a concrete plan? Audience question. If a defendant completed inpatient but relapsed soon after, should the court try a higher intensity track, like a therapeutic community, or say enough and revoke? If you were on the bench, where do you land?
All right. Is there anything you wish to say?
Your Honor,
Can you raise your right hand for me? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God? All right. You can lower your hand, state your name for the record.
Ruben Rendon Jr.
All right. What do you wish to say?
Your Honor, I did learn a lot from the good people at Lifetime Recovery, and the one thing I didn't follow through really messed me up, and I stayed with the. I should have changed the people, places, and things like Darnell taught me, and I did not follow through. And I know that if I'm given this chance, Father, Your Honor, to do this again, I know I've got to do this right. I have grandkids, and I definitely don't want to be put away for the long time that they're trying to put me in. But I definitely know I can get this right, and I need to get this right. Your Honor, I'd like to please have this chance.
Listen closely to Ruben's allocution. He accepts responsibility, cites what he learned at Lifetime Recovery, and, crucial detail, admits he didn't change people, places, and things. That's textbook relapse risk. He invokes grandkids and asks for one more chance. Classic mitigation themes. For many judges, sincerity isn't what you say. It's what you can verify. Attendance logs, clean tests, stable housing, and a relapse prevention plan. The missing puzzle piece here is consistent show-ups to drug court. The program can't help a ghost. Do you hear genuine insight or just courtroom survival talk? And if you'd craft a redemption plan, what specific guardrails would you impose to prove he's ready?
All right. So, Mr. Rendon, felony drug court is a very intensive program, and they're there to help you. And if you don't show up for them, then nobody can help you. And it appears that you stop showing up. And I know that felony drug court will spend time trying to work with you. Even if you were to abscond, they will send people out. I've seen probation officers try to go out and find people. The police try to go out and find people. But when you don't show up, there's nothing.
Decision time. Revocation granted and 5 years TDCJ, notably less than the state's 6-year ask. That's the judge splitting the difference while still sending a firm message. Key add-on, a request for therapeutic community TC inside prison. Translation, it doesn't extend custody time, but it's a structured, evidence-based program aimed at addiction and criminal thinking. Also important, credit for time served and credit for successful inpatient. Those credits matter on the back end. The judge then reviews limited appeal rights and the weapons prohibition tied to felony convictions. Finally, a rare human touch. Post-release, come back and I'll help find a sober living slot. Tough but not heartless. Fair outcome or missed opportunity for community treatment. Sound off.
That we can do. I'm going to grant the motion, revoke you, give you credit for any time served. I'm going to sentence you to 5 years in the prison, give you credit for any time served for any successful inpatient treatment. And I'm going to request the therapeutic community for you. Therapeutic community doesn't increase the time that you're in custody. However, it does help you with any addictions you may have. Do you understand? All right. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
Yes.
All right. Because this is not a plea bargain agreement, you do have a limited right to appeal. That right to appeal is as it relates to the allegations in the motion, not the fact that you were on community supervision. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you need to speak to an attorney. Do you understand? All right, we can go off the record. When you're released from prison, if you cannot find a sober living home, or if you can't find somebody to help you with your drug addictions, if I'm still here, you come back here. I'll pick up the phone, call a place to help you, okay? All right, thank you. Who else is ready?
Sean, are you ready? Yes.
All right, State, are you ready?
Yes.
All right, the court is calling 2025 CR 004887 State versus Juan Alberto Martinez. Could I have parties announce?
Megan Galloway for the state.
Robert Featherston representing Mr. Martinez.
And are you Mr. Martinez?
Yes, ma'am.
All right, first things first, defense, you requested a PR bond for your client and
New case, new stakes. Mr. Martinez previously on a $10,000 PR bond. That's personal recognizance. Release based on promise to appear, not upfront cash. Defense says he missed a drug test in Laredo because the lab wanted $75 he didn't have. A real-world poverty penalty problem. But the state isn't focused on the fee. They stress a May 13th noncompliance, claim he picked up 2 new cases in Laredo, and frame him as a flight risk. Here's the tension. Courts don't want to jail people just for being broke, but they will detain if patterns suggest non-appearance or new offenses. Should inability to pay testing costs factor into bond decisions? And if so, how? Drop your policy take.
the defendant was to be interviewed. Is that correct?
That is correct, Your Honor.
All right, the court is in receipt of the interview report. State, have you had a chance to review it? All right, if you'll pass that to this one. All right, thank you. All right, defense, is your motion?
Thank you, Your Honor, by way of proper. Judge, Mr. Martinez has no bank accounts, no personal property.
Sorry, just a moment. Excuse me. If y'all could wait, we're on the record. Counsel, you may continue.
Thank you, Your Honor. No personal property of note, no vehicle, no boats, no real property. He relies on his mom down in Laredo. His home is in Laredo. Judge, the court does need to know that there was a violation report on May the 13th for failure to take a drug test while he was down in Laredo. Judge, the testing agency down there in Laredo demanded $75 from him that he just did not have. And was unable to get his testing completed. Judge Castro went ahead and increased his bond to $25,000, and he's been in custody ever since and being picked up for that bond increase. He was originally given a PR bond back on February the 26th of this year by Judge Navra. Very respectfully requesting that the court consider putting him again on a PR bond and allowing him to reside in Laredo during the pendency of this case. Any possibility of giving Mr. Martinez a break on any drug testing charges would be appreciated if this honorable court were able to do so. And I thank the court for its time.
All right, state.
Yes, Judge. So I would just ask you to take judicial notice of the court file, but I just want the record to be clear. The defendant was granted a PR bond on February 26th of 2025 in the amount of $10,000. And bonded out, and then he receives the violation report on May 13th of 2025 for non-compliance, and that was for failing to complete the random drug testing. And then after reviewing, I guess, defense's exhibit of the PR interview, it would appear that the defendant proceeded to pick up 2 new cases in Laredo, Texas while he was on bond. And so given those facts, I think he's a flight risk based on what I read. He has sufficient ties to Laredo, and it appears like he has family that lives down there. And I guess if he was living with that family when he picked up those new cases, I don't think that that's a good environment for him to return back to. Additionally, give me just- I think the record is clear that, I mean, the PR bond is not sufficient for him to appear in court because he was previously been granted one and did not appear after that violation report. That's why the warrant went out. And I don't think he was picked up again until he was booked in Laredo and then extradited back here. So we believe that the bond is set and is sufficient and everything. I would also offer State's Exhibit B1 for purposes of this hearing.
All right, have you?
No objection for purposes of this hearing.
All right, then, states B1 is admitted for purposes of this hearing only. Just give me a moment to review.
Thank you, Your Honor.
All right, the court has reviewed states exhibits B1 and the court has reviewed the PR bond interview with pretrial services. Any response to the state's argument?
If the court will allow.
Yes.
Judge, there really is no evidence in front of this court with respect to flight risk unless you consider Laredo itself to be a flight risk. But there's no testimony that he had connections across the border. There's no testimony that Spanish is his principal language. Really, the only issue with respect to flight risk would be to say that his principal residence is Laredo.
Mhm.
He has two new allegations against him, but they're allegations down in Laredo. If the court grants a PR bond here, he has to go back to Laredo to answer those new allegations. So that he'll be transferred by the state back down to Laredo to take care of those particular issues. Judge, I have nothing further.
All right, thank you. All right, after reviewing states exhibits in the pretrial services interview for a PR bond, the motion for, or the request for a PR bond will be denied.
Okay, thank you, Your Honor.
All right. And then are you all ready to take up this other motion?
Judge, I need more time to get with my office to see if we have the resources to do what's outlined in the CCT or if we need to do the in-court. So if I can have a little bit more time on that.
And so counsel, the court understands that whatever the state's resources are, there or lack thereof, doesn't play a role in the court's decision on what should be granted. Like if there's not funding for something, I'm going to follow the law whether there's funding or not. So
Thank you, Your Honor. With respect, well, two things. With respect to the bond hearing today, would the court reduce his bond from 25 to a different figure of?
no.
You want to keep it at 25?
Yes.
With respect to the identity hearing, Judge, we would like to have the identity hearing as quickly as possible, pursuant to the court's calendar. And also in my motion, I requested a protective order that the detective that's the subject of the identity hearing not be shown any booking photographs of Mr. Martinez until after either an in-court lineup is done or the Code of Criminal Procedure 7-photo lineup.
All right, well, let's do this. Let's have you, if you'll confer with the state on a time to have this hearing. And then if you all approach the coordinator and let me know what time you all have agreed upon, and then we will set it and we'll have it.
You're most kind. Thank you, Your Honor.
All right, thank you.
Just one question. Do you want that hearing like around the jury trial, like we're doing it on Monday and beginning of jury Tuesday?
We could do it that way because I know we haven't set a jury trial in this case. I mean, a jury trial date.
That's correct, Judge.
Because their final discovery is October 20th.
That's correct, Judge. And the issue is now, he can't make his bond.
Okay.
So he remains in custody. However, if we get an identity hearing done as quickly as possible, it may turn out that the state is going to dismiss this case based upon the results of the identity hearing. Conversely, if the identity hearing does not go this way, it may end up in a plea.
Well, let's do this. With regards to the identity hearing, it will be no later than October 20th.
Thank you.
But if you all are able to come to an agreement to have it sooner, then we'll have it sooner. But at the latest, October 20th, because you're already set here in the court on October 20th for discovery.
Does the board have a preference as to whether it would be a in-court live lineup or whether the photographic procedure would
Oh,
be sufficient?
I'll let you confer with the state because they're saying there may be some resource issue. So maybe if you confer with the state, maybe y'all come to an agreement that it's a photo lineup if I grant your motion, or y'all may say in person. I don't know if they can find people in person. It's sort of, it reminds me of the episode of Brooklyn. What is it? Brooklyn Nine-Nine,
Oh, yeah.
where they do the lineup. And when they do the lineup, the lady says, I just remember them singing that way. And so he said, everybody sings a note. So I don't know if they'll be able to find people to come in for a lineup. They may only be able to do it by photo,
Well,
unless we have some actors. I don't know.
Judge, I understand that. Years ago, in Travis County, we had to do a pickup jury where the bailiffs went out in the hall and just found people, pulled it in, and then they became the jury master.
Oh, wow.
So, we have that option here if necessary.
All right. Well, just let me know. And if you all get together and give me an idea of when you all want to do that. And as I said, Mr. Martinez, the latest will be October 20th.
Thank you, Your Honor.
All right. Thank you. Thank you, counsel.
2 courtroom crossroads, 2 lessons. In Rendone, repeated non-appearance and a new offense tipped the balance from treatment chances to revocation. But the court still threaded accountability with rehabilitation via a therapeutic community recommendation and credits that matter. In Martinez, the judge weighed missed testing, alleged new cases and appearance history, ultimately denying PR bond and fast-tracking an identity hearing by October 20th. A clear signal that logistics and fairness can coexist when the court insists on speed. Big picture. Compliance and credibility drive outcomes. Money issues complicate. But public safety and court appearance risks rule the day. If you found this case as shocking as we did, hit like, tell us your verdicts in the comments, and subscribe for more jaw-dropping courtroom breakdowns. New episodes every week.